Good morning. I'm Joshua Gordon. I represent Donald McMullin, who was fined for not having permits. The town of Wakefield would paint this case as merely a contest of credibility, a reputable town inspector versus a pest, uglifying a lakeside community. But that isn't it. This case is about property rights and the rule of law. Even if you regard everything Mr. McMullin said as a flat-out lie, there's not enough evidence here to sustain the violations, and not enough evidence for a town to tell a man what he can't do with his property. Wakefield claims that Mr. McMullin violated its ordinance by cutting one tree within 20 feet of the pond, but the town didn't even have a tape measure. There's no evidence beyond the inspector's guess how far the tree was from the pond, and we don't even know where the inspector guessed from. The water's edge on that day, the low water mark, the high water, mean high water mark as the ordinance requires, we don't know. The town also claims that Mr. McMullin violated the Shoreland Protection Act by cutting trees within 150 feet of the pond, but the town didn't measure that either. The Shoreland Act is complicated. To be a violation, you have to cut more than 50% of the basal area of trees and 50% of saplings within a 20-year period. I'm not sure what it means, but there was no evidence of what it means. The town offered no percentage of basal area, no percentage of trees or saplings, no period of time over which to average. It offered no calculation and no figures from which the court could have calculated. I'm not here asking for CSI, but there's got to be something more than guesses. The assertion of a junkyard is equally loose. The town alleged that some of the cars, it didn't identify which, were not roadworthy, its word.
But there were photographs.
There were photographs. They're from far away, and they don't betray unroadworthiness, and they certainly don't look like disassembled cars. To be a junkyard...
What does it have to be a junkyard? In your brief, you cite this, motor vehicles which are no longer intended or in condition for legal use, according to their original purpose, whatever that means. But it's a pretty broad definition. Is that the definition we're working from?
Well, I believe so. I think there's two halves of it. To be a junkyard, the cars have to be junked, dismantled, or wrecked, and those are quotes from the statute.
Right.
And no longer intended or in condition for their original purpose.
So it has to be either one?
I think it's got to be both.
Oh, okay.
But even if it's got to be either one, there's no proof of any of that. They're not junked, dismantled, wrecked. They're not intended for their purpose, or if they are, there was certainly no evidence of that. The evidence that the town admitted that its evaluation was conducted when the cars were under 4 feet of snow, and it didn't know. The quote from the town inspector is, "I don't know whether they're operable." And the cars appear intact if you look at the pictures. And the neighbor and the town admitted they had been moved around by Mr. McMullin. So not only is there no evidence or no proof of the statutory requirements, whatever they are, but the evidence offered by the town itself contradicts its allegation. The box trailers. In Wakefield, you need a permit for structures. The town's ordinance, in accord with the law nearly everywhere, I think, is that to be a structure, the thing must have a fixed location on the ground or be attached to something that does, something like pipes that lead to a septic system. Recognizing the trailer's wheels, their intact hitch mechanisms, and having no connection to the ground, the town essentially admits they're not structures.
Did they have wheels on them?
Yes. Rather, the town suggests they somehow became structures just by sitting there. And even if they didn't need a permit when Mr. McMullin first towed them there 20 years ago, they need one now.
What are they used for?
Well, the evidence, the town inspector saw tires in one of them. Other than that, it's on the record. What's wrong with the trailers is they're ugly, but that doesn't necessarily make them illegal. There's a steel one-car garage, and you can see that in the pictures as well, had a permit when it was built in the 1980s. But even if it didn't, it probably was exempt under the ordinance because its value is less than $600 probably, and it isn't a living quarters. When Mr. McMullin rebuilt it in the 1990s, he didn't need a permit because the ordinance only applies to new uses. The town urges you to take the word new right out of its own ordinance and require a permit for every shed, regardless of its value, its purpose, or that it replaces an existing use. Finally, I want to talk about the latches. Latches ensures that after some while of tolerance, a town can't come back and say, well, oh yeah, you know that thing you built 20 years ago, well, it needed a permit, and if we don't want to give you one now, sorry, you have to tear the thing down. But permits are prospective. Before money is spent on material and construction, it gives the town an opportunity to consider changes. If something was done improperly way back in the last millennium and it's been long tolerated, the town's opportunity to address it dissipates and eventually disappears. Thank you.
Could you comment on the testimony cited in the town's brief by the defendant where the court asked him, so your testimony is you cut the trees, which are shown here, yes. You don't dispute you cut the trees. What's your comment on that?
Those trees, I think, in that portion of the transcript is talking about the Shoreline Protection Act now and not the town's 20-foot buffer. Okay. There's no dispute that he cut the trees, but he owns 450 some odd feet of shoreline, and to make that 50% of basal area and saplings and all that stuff, you have to measure a lot more than count some stumps, and there were 15 or 20 stumps. You got to do a lot more than that, and there's just no evidence of any of that.
And on that point, does the town have a separate right and ability to enforce the Shoreline Protection Act, or is that a state function?
Well,
I think the statute allows the town to do it.
I think the statute allows the town to do it.
All right, thank you.